Appeal of Ervin against Bahamas Power and Light.
Ms. Python.
May it please you, my lords, I am Travette Python, and I appear along with Mark Rule, and we are instructed by Python Farrington Chambers for the appellants. My learned friend, Dwan Rogers, and with him, Catherine Bailey, are instructed by Sheridans for the respondent. My lords, my lady, I wish to commence my case with a few opening remarks, if I may, to put this case into perspective. As your lordship will no doubt be aware from the papers, the facts and issues which arise in this case are not very complex and can be stated in a rather narrow compass. The central issue that arises for the board's consideration is whether the Court of Appeal was right to reduce the quantum of damages awarded to the appellant by the Supreme Court in a claim for breach of his employment contract on several grounds by nearly 75%, having upheld the first instance court's decision that the termination of the appellant was in breach of his contract of employment. And, my lords, we say that this drastic reduction of the award was not done on any principled basis, but by the Court of Appeal substituting its discretion for that of the trial judge on the basis that the judge was overly generous, or as it was put by the Court of Appeal, on the basis that there was no evidence to support such a handsome windfall. The determination of the central issue, however, raises firstly an important point of principle, and secondly, an issue of interpretation in employment and labor relations law in the Bahamas. The first issue is this: how should the courts approach the assessment of damages for dismissal without notice and without cause, which amounts to wrongful dismissal in breach of express terms in the contract of employment, in light of sections 4 and 29 of the Employment Act? This is because while section 29 sets out a statutory formula for the determination of damages for dismissal without notice, based on the length of service and the position occupied by the employee, section 4 enables an employer and employee to agree employment terms which may be more beneficent to the employee than the provisions of section 29. Thus, my lord, we say that there is somewhat of an inherent tension between section 4 and 29, and as this case illustrates, it is not always easy to determine whether the assessment should be done pursuant to the fixed terms of section 29 at common law or pursuant to contractual terms. As the board will see, the employer initially thought that the provisions of section 29 regulated the position and calculated the damage in accordance with that section. Both the Supreme Court and the Court of Appeal held that this was wrong, and this position has not been challenged. The second issue is this: does the express right of an employee not to be unjustly dismissed, as contained in Article 14.2 of the Industrial Agreement, 1, do nothing other than re-express the requirement to provide reasonable notice, as the respondent contends; 2, equate to the statutory remedy of unfair dismissal created at Section 34 of the Employment Act, as the Court of Appeal thought it did; or 3, impose a separate duty on the employer not to act in an unjust or unfair manner in terminating an employee, even where no cause is being alleged. My lords, the facts of this case can be stated shortly and are set out in the appellant's case at paragraphs 2 to 4. They are not largely in dispute between the appellant and the respondent. But if your lordships will permit me, I will reiterate them for convenience. The appellant had been employed by the Respondent Power and Light Company for 30 years when he was terminated with immediate effect on the 22nd of September 2017 by letter and escorted off the property by security officers of the Respondent.
Ms. Python, I don't think we need trouble you to take us through all the facts. We have read the papers.
Thank you, my lord. Thank you. My lord, the trial judge, in a ruling dealing with liability, found that the employer was liable for breach of contract, and the Court of Appeal agreed. She then went on to award him damages of $750,000 and 12 cents and 58 cents, and it was reduced to $620,631.88 to account for various sums and bonuses already paid to the appellant on termination and during the course of trial. The Court of Appeal...
The judge made an award on the basis of notice running to the retirement age of 60. The Court of Appeal reversed that and used a period of 18 months as the reasonable period.
Yes, my lord.
And there were some additional sums.
To account for other entitlements that the appellant would have been entitled to. That's correct.
Isn't the real issue, the one you identified as the second point, what the meaning is of the reference to unjustly terminated?
Yes, my lord.
That's the crux of the case, isn't it?
That is the crux of the case. And my lord, the respondent argues that unjust dismissal ought to be equated with unfair dismissal as set out in the Employment Act. My lord, we disagree. We say that unjust dismissal ought to be equated with unjustifiable dismissal, and the board has dealt with two cases out of Jamaica where the board found or concluded that unjustifiable dismissal ought not to be narrowly construed as meaning a dismissal which is unfair or wrongful.
So what do you say it adds?
Beg your pardon, my lord?
If it's not equated with unfair dismissal, what do you say it adds to a breach of contract ordinary wrongful dismissal claim?
My lady, we say that terms such as unjust and unfair are protean in nature, and that the court ought to construe them based on the circumstances of the case. And
but it can't just be a matter of deciding what the judge feels is unjust, can it? There must be some more precise criterion than that. You can't just leave it to each judge to do whatever feels fair or just.
Yeah, I agree, my lord. We accept that point. But we say, my lord, that it ought not to be equated with unfair against the background or construed by reference to the Employment Act.
But so what do you, I understand what you say it ought not to be, but what do you say it ought to be?
My lord, we say that it ought to be equated with fairness, principles of fairness and justice, and the court ought to import some equitable consideration into the concept of unjust dismissal. We accept that it's not clearly set out in the Employment Act and in the Industrial Agreement, but, my lord, we say that unjust ought not to be so narrowly construed so as to try and fit it in within principles of unfair dismissal as set out in the Employment Act. It is too narrow a construction, we would respectfully submit.
What's the principle in this case of justice which was breached?
Beg your pardon, my lord?
What is the principle of fairness or justice that applies in this case?
My lord, the appellant had been employed for 30 years. He clocked into work on the 22nd of September and was handed a letter. The letter does not set out any reasons for his dismissal. He had had a stellar record for 30 years with the respondent company. He was handed a letter and escorted off the premises by a security guard. My lord, we say that the circumstances of the dismissal itself was unfair or unjust. He was not, my lord, even given an opportunity to respond. He was not given a letter
All of those points, sorry to interrupt you, all of those points would fall within unfair dismissal. That's exactly what unfair dismissal under the statutory regime, both procedural and substantive, is all about.
We accept that, my lord.
So I thought you said unjust is not to be equated with unfair.
My lady, what we submit is that it ought not to be defined so narrowly as equating to unfair. That principles such as fair play, as principles requiring the employer to allow the employee a right to respond, the principle of natural justice,
Yes,
all of that ought to come into play.
But that does come into play in unfair dismissal. That's what unfair dismissal procedurally and substantively is all about.
Yes, my lady.
So I don't understand what the difference is on your argument.
The difference, my lady, is that with respect to the remedies available for unfair dismissal, because unfair dismissal, my lady, would not take into account contractual rights with respect to reinstatement.
But there's a statutory right to reinstatement.
Not under the Employment Act, my lady.
I thought there was.
Under the Employment Act, the Industrial Tribunal, on hearing a reference or a claim, may order reinstatement.
Yeah.
Under the Industrial Agreement, if the court finds that an injustice had been committed, the employee had a right to reinstatement. There was no discretion. It was not discretionary. It was mandatory. So the difference...
So is your case simply that the remedies are different, but otherwise unjust incorporates all the statutory unfair dismissal rights?
Milady, we would accept that definition of unjust, except to say that if we were to equate unjust with unfair, which this board declined to do in the Jamaican Flour Mills case, then we would again be putting the concept of unjust squarely within the Employment Act. And we must keep in mind, milady, that when these agreements are negotiated, they are negotiated against the background of unfair dismissal. The Employment Act does not change. The right not to be unfairly dismissed is a statutory right. The industrial agreement did not, or the parties to the agreement did not decide to use the word unfair, and milady, we submit that the reason for that was to avoid having to fit the dismissal squarely within the requirements of Section 29 or the Employment Act, that the intention was to give it a rather broader interpretation to include not just dismissal which are unfair pursuant to the Employment Act, but any reason when judged against the dismissal itself that may make the dismissal unjust.
The legal basis for the claim for unjust dismissal then would be breach of contract.
Yes, my lord.
And you referred to principles in that regard of natural justice, of failure to adhere to principles of natural justice. But how do they apply in a situation where he's dismissed without cause?
Well, Lord, that's the crux of the problem. Unfair dismissal under the Employment Act requires that the employer treats the employee with, I don't want to say decency and fair play, but the Industrial Relations Act and the industrial agreements that are negotiated pursuant to the Industrial Relations Act, it appears to be that our submissions is that the intention was not to try and fit the range of dismissal or the causes of dismissal within the definition of unfair under the Employment Act. But I do accept, my lord, that there are no criteria for unjust dismissal. It's left almost to the discretion of the court hearing the particular claim. There are no set criteria that says unjust dismissal will occur if the employee is not given an opportunity to be heard.
Well, what do you say it adds to the claim for wrongful dismissal in this case?
My lord, wrongful dismissal, again, we must accept, my lord, that the pleadings were not at all clear on what it was that was being pleaded under the various heads. We must accept that. Wrongful dismissal, we say, my lord, refers to the requirement to give reasonable notice or to take into account the criteria set out in Article 14.2 with respect to length of service, age, alternative employment, etc. But the breach of contract claim, my Lord, we say go to the issue of the circumstances of the dismissal. Was it fair? The manner in which he was dismissed, was it fair?
Suppose it were to be interpreted as you suggest, and that it deals with the manner of dismissal, the fact that he's dismissed without any warning, without any reasons, without any opportunity to have an explanation from somebody. How do you calculate the damages for that? I mean, it doesn't translate into notice, does it?
No, my Lord, it doesn't.
Should it not then, if you were right, be some sort of general damages for injured feelings or something of that sort?
No, my Lord, we say that under the industrial agreement itself, Article 15.14, if it is determined that the employee or an injustice had been committed as a result of the employee's dismissal, then 15.14 requires the employer to reinstate and pay the employee any lost wages.
But Clause 15 only applies in a disciplinary case. That's a dismissal with cause.
Yes, my lady.
So what happens if you have, as here, a dismissal without cause on payment in lieu of notice?
Lady, we say that Article 14.2 does in fact give the employee a right to dismiss on giving notice or payment in lieu of notice. We accept that. Then we say, it goes on to say, however, the dismissal, the employer shall not unjustly dismiss the employee. We say that that imports that even where payment is made in lieu of notice and where that payment may be sufficient, the court or the tribunal is still mandated to look at the circumstances leading to the dismissal itself. And we have included in our submissions the decision in Andrew Gilbert and BEC, where the Court of Appeal of the Bahamas actually said that Article 14.2, or a similar article, which was 11.2, requires the employer not just to pay reasonable notice pay, but also to look at the justification for the dismissal.
But that was a case where Article 15 did apply.
Yes, my lady, we accept that.
I'm still struggling to see how, if you accept that an employer can terminate for no reason, which at common law an employer is entitled to do, with a payment in lieu of notice, where these procedural obligations can come in.
Well, my lady, the respondent accepts that the industrial agreement is the contract of employment between the parties. Yeah. And we would argue, my lady, that the terms of the industrial agreement, as they represent the relationship or governs the relationship between the parties, at minimum, the employee is entitled to the disciplinary procedure that's set out in his contract of employment.
But not
at
if
minimum.
There's no disciplinary case against him. He can't insist on a disciplinary procedure if no disciplinary case is pursued, can he?
No, my lady, but if we look at Article 15.17, Article 15.17, I'll take your lady, my lords, to it.
Page 436.
Article 15.17
Yes.
my lords, it says there, when an employee is warned, suspended, or dismissed, a written notice of such warning, suspension, or dismissal shall be given to the employee and the union, setting out the reasons for such warning, suspension, or dismissal. Notably, my lords, it does not say that when an employee is dismissed pursuant to this article. It says when an employee is dismissed, he shall be given a letter setting out the reasons for his dismissal.
Well, there's a list of things up above that, like dishonesty and gross insubordination and so on, which are the kind of reasons, aren't they, that we're talking about, for example. We're not talking about a case when there's no reason being relied on.
How can reasons for the dismissal be given in writing when on the side there are no reasons? It's done without cause.
My Lord, we accept that that the respondent contended that the dismissal was without cause. The argument for the employee is that even under, if we accept, as the Court of Appeal did, that unjust equate with unfair, the court will still investigate the correctness or the procedure which led the employer to dismiss.
But why? I mean, if the employer has simply a right to dismiss with notice for no reason at all, what would be the point of investigating the procedure by which he's decided to exercise that right?
And that's why, my Lord, we say that Article 14.2, that says the dismissal shall not be unjust, must import something more than just payment in lieu of notice. If we accept that payment in lieu of notice is sufficient because an employer has a right to dismiss without reason, Article 14.2, that says it shall, however, the dismissal shall not be unjust, becomes mere surplusage. It must have been put there for a reason. Otherwise, an employer can dismiss pay notice and then be done with it. But Article 14.2 says, no, you pay in lieu of notice and take into account considerations such as age, etc., but the dismissal itself shall not be unjust. And it's unfortunate, but it's true, that the industrial agreement does not set out what would constitute unjust dismissal. But, my Lord, contractually, the employee was entitled not to be dismissed unjustly.
But at the moment, a problem that I'm having is that you are not able, I think, to clearly distinguish unjust dismissal, which you claim is a contractual regime, from the non-statutory unfair dismissal legislation, because I think you're accepting that insofar as there's unjust breach of contract dismissal, it would be covered by the unfair dismissal legislation. Is that correct?
Yes, my Lord.
I mean, you're not giving us any circumstances where there will be a difference. So one might think, well, why isn't the claim that the individual here has one to unfair dismissal if you are the statutory unfair dismissal, if you're complaining about the fact he's not being given, he shouldn't just have been dismissed by giving notice. Well, why isn't the unfair dismissal statutory regime everything that your employee needs and needed?
My Lord, to answer that, the unfair dismissal statutory is a statutory claim. Every employee has a right not to be unfairly dismissed under the Employment Act. That is the position under Bahamian law. When the industrial agreements were negotiated, had the parties intended to simply limit the right not to be dismissed to the statutory regime, they could have very well said so. That is not to say, my Lord, that unfair and unjust cannot be equated, because we have no real authority to say that unjust dismissal must be treated different from unfair, except for this board's decision in Jamaica Flour Mills and University of Technology, where this board said that unjustifiable dismissal ought not to be equated with unfair or wrongful or even unlawful dismissal. The point, my Lord, I think which we seek to make is that unjust dismissal, or the right not to be unjustly dismissed, must import a bit more than what the statute says. But we must accept that there is nothing or no criteria that will set out or that sets out what constitute unjust dismissal, except for a right to be treated fairly and justly.
But it's going to produce, I think you're going to have to take us to these authorities that say that there is this separate regime, because on the face of it, it sounds like a recipe for absolute chaos.
Yes, my lord, it does, because again, like I said, we have the Employment Act, which came into play in 2002. These industrial agreements run for 5 years. Every 5 years, they review them. However, none of the bargaining units, for whatever reason, decided to insert unjust as opposed to unfair. And my lord, when you look at the final sentence in Article 14.2, which I'll take you to, it actually says that the payout ought to be no less favorable than what an employee would be paid under the Employment Act. And my lord, I'll take you to that point. Article 14.2.
433.
At 433 actually says, at 14.2, the corporation may terminate the services of an employee by giving reasonable notice. And then it goes down. The corporation shall, however, not terminate an employee unjustly. And then it goes on further to say, and the compensation shall be no less favorable than what is paid to an employee under the Employment Act. So it seems, my lord, that one can argue that the parties anticipated or certainly negotiated against the background of the unfair dismissal legislation and decided that they wanted unjust dismissal to be included and not to be read as meaning unfair dismissal. Because certainly they could have said it there. They could have said the payment or the compensation shall be paid in accordance with the unfair regime and not the unjust regime, which again, like I said...
Couldn't it be read as saying that, in effect, you've got a contractual right to whichever is the better of the reasonable notice payment and what you would have got had you claimed under the Act?
Yes, sorry, my lord?
Could you not read this clause as saying that you giving the employee a contractual right to have to receive whichever is the greater amount of compensation as what you would get by calculating reasonable notice, or what you would get by calculating what the person would have got for a claim under the Employment Act?
Yes, my lord. Section 4 of the Employment Act actually says or maintains the right of a party to pursue greater rights if the Employment Act is, for whatever reason, insufficient compensation.
Yes, so Section 29 sets a floor.
A minimum,
Yeah,
yes.
a minimum.
Minimum.
But this clause,
this is
can't
going
it just be
further.
read as saying that whatever, come what may, you won't get less than that?
Yes, my lord. That's exactly what it says. But, my lord, the point that I make is that the bargaining agents recognize that the unfair dismissal regime set a minimum payment, and they've agreed that the compensation payable under Section 14.2 will be no less favorable. But, my lord, even if you were to accept that unfair and unjust dismissal are one and the same, the Court of Appeal would still have erred because, and I'll say this, my lord, under the unfair dismissal regime, an employee who was unfairly terminated is entitled to a basic award and a compensatory award.
Yep.
So if we equate the two, he would still have gotten more than the Court of Appeal awarded.
Because he's a manager and he's entitled to 24 months under Section 48,
Yes, ma'am.
rather than 18 months.
Yes, my lady.
But what my lord was putting to you, I think, was that all this means is that you will get the better of either what the contract yields by way of reasonable notice or what Section 29 yields.
Yes, that is correct.
Not all the other rights pursuant to Section 34 of the Act.
That's an interesting way to put that point, my lady. The way our submissions, my lady, would be that Section 14.2 lists those requirements
Yeah.
on the payment that the employer is obligated to consider on termination. we submit, my lady, that those considerations play no part in an award for notice under the Employment Act. There's no requirement under the Act or for dismissal under the Act for an employer to consider things like the chances of alternative employment, to consider things like age, etc. Those prescription or criteria are only relevant when one comes to consider Section 14.2 on the payment of notice under the contract. None of those considerations are relevant or come into play on an unfair dismissal under the Employment Act.
Do you mean Section 29?
29, yes, Section 29. So none of those considerations.
Minimum notice periods by reference to the years of service.
Yes,
yeah.
And the other criteria listed therein.
Yeah.
Before you move on, can you just help me in relation to 29(1)(c)? I'm looking at it in your written case at paragraph 29. The case comes within C because Mr. Dean held a managerial position.
Yes, he did.
So the minimum period of notice shall be 1 month's notice or 1 month's basic pay in lieu of notice, and 1 month's basic pay for each year up to 48 weeks.
Yes, my lord, that's...
What does that mean?
So up to 48, there's 48 weeks impose a ceiling.
Yeah.
Or the notice pay.
Yes.
Yes, my lord, this is the provision pursuant to which the respondent dismissed the employee and paid pursuant to Section 29(1)(c).
Yes, I understand that, but you said a few moments ago that the award made by the Court of Appeal was less generous than the statutory entitlement under 29(1)(c).
No, my lord.
If it was 18 months, it was more generous than...
No, my lord. What I meant to say, perhaps I was not very clear. If the Court of Appeal, which it did, equated unjust with unfair, not only would the employee be entitled to notice pay as set out under Section 29, but he would have also been entitled to a basic and a compensatory award under Section 46 of the Employment Act.
Yes, I see.
Yes, so it was not merely employees dismissed unfairly are entitled to notice pay, and if the court determines or the tribunal determines that the dismissal was unfair, they're also entitled to further payments under 46 and 47 of the Employment Act.
The notice pay under 29(1)(c) is up to a maximum of 48 weeks.
We accept that.
Mr. Dean, thank you very much. Sorry, I interrupted.
No, so it's just under a year is the maximum, or just under 12 months is the maximum you can get for notice pay.
My lord, while we are on that point, perhaps I'll take...
Just before you leave that, so you're saying, had the claim been brought for unfair dismissal under the statutory regime, the employee would have been entitled to more than the award of the Court of Appeal has given?
Yes, my lord.
Well, that depends. I think what you're saying is the maximum award would have been more, because it would have depended. An assessment of a compensatory award isn't just the maximum.
It would have depended on a finding of whether or not the dismissal was unfair.
It would have depended on all sorts of things. Even if it was unfair, the compensatory award is not automatically the maximum to which the employee is entitled.
No, it's not. No, my lady.
So the maximum award was more than what the Court of Appeal awarded.
That's correct.
But it isn't necessarily what this appellant would have received.
No, my lady. The appellant was also entitled to other heads of damages, which the Court of Appeal accepted, and which fell under his contract and not under statute.
But his claim was only brought as a matter of breach of contract. He didn't pursue a statutory unfair dismissal claim. Do you accept that?
We accept that, my lords.
But you rely on the fact that under the contract it has to be no less favourable than the entitlements provided for you. But do you say it was less favourable?
Yes, my lord. We say it was less favourable simply because, again, under Section 29 of the Act, the criteria set out at 14.2 need not be considered. And the Court of Appeal accepted that those criteria were not considered, and so that the notice pay was not sufficient.
But sorry, I thought you said in answer to my Lord Lloyd Jones that you accept that what the Court of Appeal awarded was more favourable than what he would have been entitled to under Section 29.
No, my lady. My lady, and if I did make that concession, I must withdraw it. Had the Court of Appeal considered or equated unjust with unfair, under Section 29, with respect to payment in lieu of notice, the Court of Appeal, yes, the Court of Appeal would have awarded, the Court of Appeal's award on the notice pay would have been more favorable.
Yes.
I accept that.
So
29(1)(c), yes.
So you can't say that the amount was less favourable than his rights under the Employment Act per
With respect
14.2.
Yes, my lady, but with respect to basic pay and compensatory award, he would have also been entitled to those.
But he didn't bring a claim under Section 34.
That's correct.
Or by reference to Section 46 to 48.
We accept that, my lady, but the Court of Appeal treated it as an unfair dismissal claim. And so our submissions is, if the Court of Appeal treated his claim as a claim for unfair dismissal or equated unjust and unfair, then they ought to have gone on to also consider the other entitlements of the employee under the statute.
To ensure that he had no less favourable an amount than he would have got had he made a claim under the statute.
Yes.
But I mean, wouldn't he have to plead that he would be entitled to a certain level of entitlements under the statute, make that good in order to rely on the closing bit of Article 14.2?
Yes, my lord, but would the...
And he doesn't seem to have done that.
He pleaded breach of the terms of his contract of employment, in particular Article 14.2. The judge found on breach of contract and gave him an award for the remaining years under his contract, which, my lord, we are not clearly, like I said, maintaining that the judge was either right or wrong. But if he had brought a claim for unfair dismissal, as the court treated it, the Court of Appeal treated it as the claim for unfair dismissal, we had not pleaded that. That was not pleaded by the appellant, but the Court of Appeal treated the unjust dismissal breach of contract claim as a claim for unfair dismissal.
Right.
But the judge treated it as a claim for breach of contract. And so therein lies the problem. At the trial, the claim was advanced on the basis that he had a right not to be unjustly dismissed, and if the respondent dismissed him, they ought to have paid him payment in lieu, notice pay, with reference to the criteria set out in 14.2. The judge found that the respondent had breached the appellant's contract. When the matter went to the appeal court treated it as a claim for unfair dismissal and calculated the award on that basis. Although they did find that the respondent had breached the appellant's contract.
Yes, thank you.
I thought one of your arguments that was being put was that under 14.2 on page 433, if one equates the reference to unjustly with the statutory unfair dismissal legislation, then the final sentence is a cross-reference to the fact that you should at least get what you would have been entitled to had you brought an unfair dismissal statutory claim. Is that what you're suggesting as a possible interpretation?
That is a possible interpretation, my lord, and we also say that Section 4 of the Employment Act supports that. But what we say is that Section 29 does not require an employer to consider anything in terms of length of service, age, etc., in paying out any compensation under the Employment Act. The contract imports these requirements. And this is why we say that the claim for notice would have been larger than one that was paid pursuant to the Employment Act. simply because there is no requirement under the Act to consider these criteria.
Well, that's understood.
Yes,
It's more the point about the unfair dismissal compensation rights, I think. And I just want to be clear, whilst a basic award is a mechanical award, it's calculated by reference to the number of complete years service with a monthly salary multiplier. The compensatory award is at large. It depends on a whole range of factors. And as my Lord Sales put to you, you didn't ever plead a basis for assessing what you might have got by way of compensatory award.
My Lady, we have to accept that the pleadings are deficient in that regard.
But even in the Court of Appeal, you didn't put forward an argument that said, this is what we would have got by way of compensatory award. So you can't treat us less favourably if you do equate unfair and unjust than the entitlements we would have achieved under the Employment Act.
The issue, my lords, is that the pleadings, and perhaps it would be helpful for me to take your lordships to the pleadings. The pleadings at trial centered on this concept of breach of contract.
Yeah, that was the limit
That was the limit of the claim.
Yeah.
When it went up to the Court of Appeal, it was the Court of Appeal who introduced, I should say, my lady, introduced this into the pleadings unfair dismissal. It was never argued at the court below. It was never pleaded at the court below. So when it went to the Court of Appeal, instead of treating it as a breach of contract claim, the court treated it as an unfair dismissal claim under the statute, even though it was never argued below.
Well, you were arguing unjust, and we're just trying to understand what you were saying, what it added. And the Court of Appeal was trying to understand what unjust actually added.
Under the agreement, my lady, unjust dismissal, and your ladyship has made the point. My lady, I don't think I can take it any further once I've made this point. The unjust dismissal claim, or the claim for breach of contract, would have added just a different remedy. His claim would have been higher, his award would have been higher, had the court considered the breach of contract claim and not treated it as an unfair dismissal claim. But even if, my lords, we accept that unjust does not add anything to unfair, unfair and unjust are one and the same, we say that the Court of Appeal ought to have gone further and considered whether or not the employee was entitled to a basic and a compensatory award. We cannot, my lady, shrink away from the fact that unfair dismissal was not pleaded. It was not pleaded in the court below. It was not argued at the Court of Appeal, but the Court of Appeal issued its judgment on the basis of unfair dismissal.
And you accept if the Court of Appeal had gone down that route, although the basic award could have been calculated with certainty, there was no basis on which to calculate the compensatory award. There was no evidence or material other than the material that the Court of Appeal had.
The compensatory award, my lady, would have been based on his pension entitlements, etc. Those were before the Court of Appeal.
But they included that in the multiplier or multiplication?
They did include it. They reduced it, yes.
So there was nothing more?
No, there was nothing more before.
Are you going to show us the cases that you referred to
Yes.
at some point?
Yes, my lord. The case of Andrew Gilbert, which was relied on at trial,
Where do we find that?
at page 677,
637, thank you.
77.
77.
And as my lady Simler has already alluded to, this was a case for dismissal with cause. But we say, my lord, that the principle which arises on this case or came out of the Court of Appeal was simply that in considering the application of Article 14.2, which was 11.2 at that time, the court ought to take a two-stage approach. And, my Lord, I'll take your Lordship to page 679. Starting at about line 12. Now, implicit in 11.2, there clearly is a right in the corporation, as indeed in the employee, for either side to terminate the contract of employment. Now, insofar as the corporation's right to terminate the services of an employee is concerned, clearly that article recognizes the existence of that right to do so. But in doing so, the corporation must bear in mind the various criteria that I have just adumbrated: length of service, age, dedication, etc. The words there, however, the corporation shall not terminate an employee unjustly, must be read in the context in which they appear. That is to say, the circumstances must demonstrably bear out the justification for the termination, and the reasonableness of the notice must be measured by the criteria therein adumbrated. The approach of the corporation, therefore, must be twofold. In the first place, the decision to terminate must be justified by the circumstances leading up to the termination. And in the second place, the period of notice must be reasonable, having regard to the criteria already mentioned. When combined, the question must be asked, did the corporation terminate the employee justly? And so, my lords, that is the sum of the appellant's case, that while the employer can terminate, the justification or the circumstances for termination must still bear out the dismissal. There must be just cause.
I find this a slightly puzzling passage because Clause 11.2, Clause 14.2 in our case, seems to give the employer a right to terminate without cause, but on giving notice. But this passage seems to say that the employer can only terminate with cause.
That's correct, my lord. That's exactly the issue that this case...
well, except that they decided that 9 months pay in lieu of notice was fair or was just.
Yes, my lord, but that was with respect to a for-cause termination. But what it's saying in relation to the point that I believe we struggled with this a few moments ago was whether or not there needs to be a reason for the dismissal. And here the Court of Appeal is saying, on interpreting that clause, that there must be a reason for the dismissal.
So it's not a power to dismiss without cause?
That's our point, my lord. Under the industrial agreement, there is no power in the employer to dismiss without cause. And Article 14.2 and the insertion of, however, the employer shall not unjustly dismiss imposes a requirement to justify the dismissal.
Right. The other thing I find puzzling about this is if they are saying that you can only dismiss with cause, they seem to say, and you have to give notice which is reasonable then as well.
Both. That's the argument.
But usually if you dismiss for cause, if it's sufficiently grave, you can dismiss without any notice at all.
Yes, my lord, except that under the industrial agreement, that seems to be, the position seems to be otherwise. And that is the way the Court of Appeal interpreted Article 14.2.
Right, but I mean,
I'm sure they could say if it was gross misconduct, no pay in lieu, it could be justified as summary dismissal, and therefore you get nothing in lieu of notice.
That's correct, my lord.
yes, well, perhaps they could, but it doesn't seem to be the natural import of the opening words of Clause 14.2, because that doesn't refer to the conduct of the employee.
It doesn't.
No. So my puzzlement is really to wonder whether what is said in Gilbert is right. at any rate, insofar as one's looking at termination without cause, Gilbert being a case of termination with cause.
Yes, my lord. The issue will turn on whether or not there was an obligation on the part of the employer to terminate in the absence of reason or cause. And Gilbert seemed to say that when you are looking at these industrial agreements, and presumably, my lords, also looking at what the intent was behind the Industrial Relations Act and the Employment Act and the Code and all of that, whether or not an employer can still terminate at pleasure. And Gilbert seems to be saying, well, in looking at this particular clause, and my lord, that's not to suggest that Gilbert is the correct interpretation, but certainly it seems to suggest that there must be a reason for the termination. And that's as far as I can take Gilbert, my lords.
I mean, it would be a very profound step to take away an employer's normal right to dismiss without cause by giving reasonable notice, would it not?
Yes, my lord. My lord, the old common law position, which the respondents also rely on, that gave the right to an employer to terminate for no reason or for any reason. I believe my friends rely on Justice Osadabe's a textbook on that point. The Industrial Relations Act, the Employment Act, and I would say, my lord, the employment and labor relations regime right now appears to be headed or directed towards, I would say, ameliorating the right of an employer to terminate without cause. And when we look at these industrial agreements, again, my lord, we must keep in mind that the Employment Act and these agreements are negotiated against that background. The Act is 2002. This industrial agreement is 2013. So if the parties intended that there be a right in the employer to terminate without cause, then we don't need a clause that says the termination shall not be unjust, because that suggests that there must be a reason. And Gilbert seems to argue, or seems to certainly support the position, that you must look at the circumstances that led to the termination to see whether or not it's justified. And your lordship dealt with justifiable dismissal in the Jamaica Flour Mills case. And we would say that...
Are you going to show that case?
Yes.
I think you've mentioned it several times.
It's at 807, my lords.
Sorry, which page?
807.
Thank you.
Yes.
And beginning, my lord, at paragraph 15. This was the case, my lord, involving a dismissal on the grounds of redundancy. And what occurred, my lord, is that the employers...
Sorry, can I just ask you, is 12.5 in that section about disciplinary dismissals, or is it about...
12.5 merely say that the employee shall not be unjustifiably dismissed. And it was a statutory provision in Jamaica.
Have we got it in the judgment? Do they quote it somewhere?
Yes, my lord, it's at 15.
Well, they don't actually quote the provision. I was just wondering if they quoted the section 12.5C.
See, I do not recall seeing the actual section 12.5C quoted. But section 12.5C, paragraph 4. Yes, my lord, it's at paragraph 4.
No.
And what it says, my lord, is section 12 deals with the award the tribunal may make. And of particular relevance to this case, section 12.5C provides that if the dispute relates to the dismissal of a worker, the tribunal shall, if it finds that the dismissal was unjustifiable and that the worker wishes to be reinstated, order the employee to reinstate him and pay so much of his wages, and if any, as the tribunal may determine.
So is that like the section 34 provisions? It's about unfair dismissal.
Yes, my lady, it is about unfair dismissal, but in this case, Jamaica does not use the words unfair. It
Uses
uses
unjust.
unjustifiable, yes. And, my lord, the court will note that on the construction of unjustifiable, at paragraph 15, the correct meaning to be attributed to the word unjustifiable in its section 12.5c context was, of course, an issue of law. Mr. Shard-Smith submitted that unjustifiable should be given the restricted meaning of conformable to law, and that unless it could be shown that the dismissals were in breach of some duty, whether contractual or imposed by statute, the dismissal could not be held to be unjustifiable. Their lordships, for the reason given in the court below, which their lordship will not attempt to improve upon, reject this limited construction. The dismissal were unjustifiable for the purposes of section 12.5c. And then, my lords, in concluding, the board went on to say that the correct meaning to be attributed to the word unjustifiable at paragraph 24 in its section 12.5c context
Why isn't this all about interpreting a statutory unjustifiable or unfair dismissal regime?
Why? I'm sorry.
As I understand it, this is a case concerned with interpreting statutory provisions.
That's correct, my lord.
The statutory provisions are what we would call unfair dismissal in this jurisdiction and in the Bahamas.
Yes.
Here it's called unjustifiable.
That's correct, my lord.
So how does that help us when we're dealing with a non-statutory regime?
Simply to show, my lord, that in looking at what it means, or considering what meaning to be attributed to unjust, the board in Jamaica Flour Mill had to deal with unjustifiable. And we say that that concept is more similar to unjust than it is to unfair.
What? Really? I mean, they're all synonyms, aren't they?
They are, my lord. But again, in the Jamaica's case, section 12.5c was a statutory provision. Here we are dealing with a contractual provision, and we have no statute that addresses this issue of unjust dismissal. The closest we can come is the consideration by the board. In this case, and in the University of Technology case, where the board had to construe what the meaning of unjustifiable was, granted it was against the background of a statute, and here we are dealing with that word or a similar word in a contract. But we say that the meanings can all bear out the same thing, or certainly should, if one is minded to equate unfair, unjust, and unjustifiable, then unjust aligns more with unjustifiable than it does to unfair, is my respectful submission. But, my lord, there is no authority on this concept of unjust dismissal, or what that means.
Except you say the Bahamas electricity case.
Yes, except for that authority.
So that's what we've really, that's the only case that might be said to have grappled with this question directly.
That is correct. And as for the rest of the authorities, none of them address the question that this board is being asked to consider with respect to what is the meaning of unjust dismissal in the context of an industrial agreement or a contract of employment.
And you say that Bahamas electricity has taken the radical step of interpreting the equivalent of 14.2 as removing the right of an employer to dismiss without cause.
That is my submissions, my Lord. Otherwise, my Lord, we'll have to interpret section 14.2 and the reference to unjust dismissal as being nothing more than a redundant statement.
Well, another possibility would be that it means that where you, for example, have two similarly situated employees, same length of service, same record, same loyalty, etc., the employer couldn't pay reasonable notice amounting to, I don't know, 1 million to one, and reasonable notice amounting to 50 to the other. That would be unjust as between the two employees.
Well, my lady, that would be unjust with respect to the payment of the notice provision. But is it unjust with respect to the manner in which the employee was dismissed?
But if you've got a dismissal without cause, all you really are entitled to is your payment in lieu of notice.
So that is why what we're arguing, my lady, whether or not under 14.2 an employer does have that, well, BPL does have that right, because you do not find that in any other contract. This consideration or this insertion that you must look, having paid, notice paid, one must still look at the justification for the dismissal. It almost says, like I said, contradictory things. If one accepts that an employer can dismiss without cause, then why do we need to investigate the justness of the decision?
Right. If I may say so, the difficulty I have with what you're submitting is that if one looks at clause 14.2, the opening words, it seems positively to say that the employer may terminate the services of an employee by giving reasonable notice in writing. In other words, no reference to for cause or anything like that there. It's positively saying that the employer has the right to do that, and that would align with the point put to you by Lord Burrows, that that's the usual position.
That is correct.
In contract law. So you're trying to get out of the following sentence a major qualification to what is said in positive terms in the first sentence.
But my Lord,
I struggle to see how you can do that. Why isn't the more natural interpretation of the second sentence in the word unjustly to look for something which is more limited in effect, as perhaps as my lady was putting to you, rather than saying, oh, well, actually, it so profoundly qualifies that first sentence that you can't dismiss by giving reasonable notice at all. You always have to have cause.
well, my Lord, the way I would answer that or respond to that is simply to refer your Lordship to how the Court of Appeal interpreted it, which is that, yes, you can dismiss with notice, but also you must look at the justification for the termination. And I could take the point no further than that. Article 14.2 gives a right to a consideration of the dismissal itself. Whether notice pay is sufficient or not, it appears as if that second sentence also gives the right to the tribunal to look at the circumstances of the dismissal to determine whether or not some additional remedy or right may arise. Otherwise, what is the purpose of that sentence there? They could have stopped at the employer may terminate on giving notice, paying notice or reasonable pay in lieu of notice. But it went on to say in the very same sentence, the very same paragraph, however, the decision to terminate must be just, or the dismissal must not be unjust.
Well, it seems to me at the moment to link very naturally with the last part of the clause, because if it wasn't for the unjustly, there wouldn't be any basis for saying the amount will be no less favourable than the entitlements in the Employment Act. If you were just looking at notice, they might, but if you interpret it as meaning unfairly, the same as unfairly, then it makes sense as giving you a contractual right not to be unfairly dismissed, and so making sure that you'll get whichever is the greater of the notice payment and what you would have got had you made a statutory claim.
Yes, my Lord, that is the position. My Lord, a point was also taken by the respondent that these matters were not pleaded, the breach of contract claim, and I'm not sure if the board wishes me to address it on that, considering that we have really gone to the crux of the heart of the matter, whether or not Article 14.2 gives the right that we say it purports to give with respect to a separate claim for something other than notice pay. But there were other points taken in the case concerning whether or not the breach of contract was pleaded, argued, and a trial, and we say that it was, and I can take your lordships to that if necessary. But certainly, like I said, the crux...
Yes, we'll hear you in reply in relation to that.
Thank you, my lords.
I wasn't.
Oh, sorry, sorry, my lord. You said...
You should now conclude your. I wasn't trying to stop you. Saying on that particular point on the pleading,
Yes,
which is taken against you, you'll be happy to hear that
in reply. Thank you, my
in the
lord.
course of your reply.
So on the issue, my lord, of the unjustifiable dismissal, and I think, my lord, I have said all that I can say about that. We make one further point, and that is, if your lordship accepts that there is nothing in the authorities, or there's nothing that imports any further consideration into unjust dismissal that makes it any different from unfair dismissal, we say that the Court of Appeal ought to have considered whether or not, as Lady Simler indicated, the appellant was entitled to be paid a basic and a compensatory award. Because had the Court of Appeal gone that far, or gone further, the award would itself have been even larger than what the Court of Appeal eventually settled on.
Well, what's your basis for saying that? I mean,
I'll take your lordships to Section 46 of the Employment Act, which is at page 571. And my lord, as a matter of background, as I would have indicated, if a tribunal finds that an employee had been unfairly dismissed under statute, the right not to be unfairly dismissed, the award includes notice pay, and it can include a basic and compensatory award.
is that right? Here, you wouldn't get double recovery. You would either get your basic award or your notice period, depending upon the length.
My lady, again, the way Section 29 reads, if the employer is dismissed, he's entitled to certain payments, notice pay or payment in lieu of notice. The way it operates certainly in the Bahamas is that in addition to this notice pay, there's a payment that's made of a basic and a compensatory award. It's not just limited to notice pay. If I understand your ladyship to be making that point.
What I'm saying is, if you're being awarded notice pay for the period from the date of your dismissal to whatever would have been a reasonable period of notice, the basic award also runs from the date of your dismissal.
Yes.
And in this country, you wouldn't get double recovery, is all I'm saying. You wouldn't get both a basic award and a notice period award.
In the
to
Bahamas.
cover the same period. But
Yes.
are you saying you can in the Bahamas?
Yes, you can in the Bahamas. And Section 46 and 47, my lords, sets out the formula for calculating the basic pay, which is similar to the way it's done in England. And then at Section 47, This section, my lords, take into account losses that would have flown from the dismissal itself.
So far as considered just and equitable.
Just and equitable, yes.
So you would expect the employee to lead evidence of, for example, the efforts that he or she has taken to obtain alternative employment and the difficulties caused with that in order to project forwards into the future and decide what is just and equitable to compensate
Yes,
for
with respect to the
unfair dismissal.
That's correct, Milady. And
So what
also,
was the evidence that you led in this case to support a quasi-compensatory award?
Milady, before I answer your ladyship, the compensatory award also takes into account any benefits that the employee would have had had he not been dismissed.
But you've already accepted the Court of Appeal
Yes.
included those.
Yes.
So the only thing the Court of Appeal didn't include, from what you've said, is an award stretching into the future that was just and equitable to reflect the loss sustained in consequence of the dismissal. Is that right?
Yes, my lady, and we will say that there was no evidence, and the Court of Appeal accepted, and we must accept it as well, even in the court below, led with respect to any efforts made by the appellant in trying to obtain alternative accommodation. Statements were made, but no evidence was led to that effect.
So why wasn't an 18-month period sufficient to reflect what was just and equitable in this case in respect of the losses sustained by this appellant in consequence of his dismissal?
We say, my lady, that the 18 months period was, for one, arbitrary, but in light of the fact that the appellant was on the job for 30 years and he had a stellar work history, the 18-month pay that the court substituted was 18 months notice pay or pay in lieu of notice. It was not intended to address the compensatory and basic award. If your lordship...
So how much would the basic award here have been? Can you give me that figure?
Yes, my lord, I can.
Bearing in mind the maxima in section 48.
Yes. The basic award, my lords, would have been 30 years times 3 weeks pay, 24 years times 3 weeks pay.
Which is what?
And we calculated that to be $135,000 to $147.60 approximately.
And why do you say 24 years?
24 weeks, my lady, not years.
24 weeks pay is the maximum.
Yes, 24 weeks pay is the maximum compensatory award.
The maximum basic award. We're talking about the basic award.
Basic award and compensatory award, isn't it? The basic award is calculated, my lady, using 3 weeks' pay for each year of his employment.
Yeah.
However, it's reduced to 24 weeks' pay when we move to Section 46.
And where is that produced in section 46? So I see section 46(1), that gives you your each complete year of employment times 3 weeks' pay. That's the starting point.
That's the starting point.
48(1) gives a maximum of 24 months for both basic and compensatory awards. But I can't see anything about 24
That's correct, my lord. 24 months. That's correct.
And that's basic and compensatory. At 48(1), the amount of compensation
awarded to the person
in accordance with section 46 and 47 shall not exceed 18 months' pay in an ordinary case, but 24 months' pay in the case of a person with a managerial position. That's how I read it.
And was that the figure you gave us, the 135,000? Was that 24 months' pay?
That was 24 months' pay, my lord.
Yeah.
Okay.
And so what about the basic? What is the maximum what basic?
Both. That's
I know that's for both, but would if it were only the basic and no compensatory, what would you get then?
30 times 3 weeks.
yes, 3, that's correct, 30 times 3 weeks. And the 3 weeks' pay is 56.31.15.
56.
5,631 and 15 cents.
I'm so sorry, I missed those figures. But what would be the basic award if you were just doing the section 46.1 calculation?
It would be 3 weeks' pay.
Yeah.
It's $5,631.15.
Sorry, can you say that again slowly, please?
5,000.
So how many weeks?
30.
30 weeks.
Yes,
30 weeks' pay, and the weekly pay?
Sorry, it's 30 times
yes,
the amount for 3 weeks' pay.
Yes.
And the amount for 3 weeks' pay is 5,631.
0.15.
So the sum to be done is 30 times 5,631,
Yeah, okay.
Yeah.
which is 15 something.
That's actually greater then than the ceiling, is it? It's about $150,000.
Yeah.
or thereabouts, yes, ma'am.
Yes, so it would be capped at $135,000, would it?
It would.
And by section 48.
Yeah.
At 24, yes.
Yes.
Yeah.
But we got into this because your proposition or submission was that it would have been more generous under the unfair dismissal compensatory regime than the Court of Appeal awarded. But that's not correct, is it? If these figures are correct.
Well, my lord, the basic pay is the 135 that your lordship has just indicated, but he would still have been entitled to notice pay as well, calculated in accordance with section 29.
Yeah, well, you said that before. Have you got authority for that?
Let's-
It seems surprising to me on the face of it.
Lord, we would have not put the calculations or any authority before the board on how the award is calculated except for the statutory, except for the Employment Act. We're just wondering,
Sorry,
perhaps,
he would also be entitled to
notice pay,
notice pay under section.
29 of the Employment Act.
Thank you.
Remind me what the minimum is under section 29? Is it 3 weeks' pay per year's service?
No, section 29 deals with the notice pay, my lady.
Yes.
And
What is the notice pay calculated under the?
the notice pay calculated under section 29, because he was a manager or senior manager,
It's 1 month's
with 1 month's pay or payment in lieu of notice
up to
and
48 weeks.
up to 48 weeks.
So he would have been entitled to 48 weeks under 29(1)(c) Roman 2.
And he would have been entitled, Millie, that's an and.
Well, you said that, but you were going to come back to my Lord Burrows about why you say that is right.
So under 29,
Sorry,
1C.
one more. Can you give us the figure for 48 weeks? What would 48 weeks equate to?
48 weeks equates to 90,100.
Right, which is what they offer.
Which is what
Can
they
you say that
paid.
again, please?
48 weeks equates to $90,100. That is what was paid on termination. And they would have also paid, pursuant to 29(1)(c), $7,500 or $7,508.
Which is
Sorry.
1 month's pay.
Sorry, say that again. Also entitled under which section?
They would have paid on termination, section 29(1)(c), C1, 1 month's notice or 1 month's
Sorry,
basic pay.
29(1)(c1).
29(1)(c)(1).
How much?
They paid 1 month's notice at $7,508.34.
The amount again, please.
$7,508.34.
Thank you.
So what the Court of Appeal did, my lords, was under section 29(1) C1, they increase the notice pay to 18 months. So they gave him an additional 17 months notice pay, or payment in lieu of notice. He would also have been entitled, my lords, to 1 month's basic pay for each year up to 48 weeks.
What, as well as the 18 months notice?
Or the Court of Appeal substituted the 18 months
Yes.
notice, yes.
Yes.
Mhm.
But so what's your authority for saying he would have been entitled to both the maximum basic plus compensatory award and the maximum minimum notice period entitlements under Section 29?
My lords, may I take you to page 570?
What do you want there?
At 570, my lord, at section 42, which is the remedies for unfair dismissal, where on a complaint made under section 41, the tribunal finds that the grounds of the complaint are proved, it shall explain to the complainant what orders for reinstatement or reengagement may be made under section 43, and in what circumstances they may be made, and shall ask him whether he wishes the tribunal to make such an order, and if he does express such a wish, the tribunal may make an order under section 43. If on a complaint made under section 41, the tribunal finds that the grounds of the complaint are proved, and no order is made under section 43, which is reinstatement and reengagement, the tribunal shall make an award of compensation for unfair dismissal, calculated in accordance with section 46 to 48, to be paid by the employer to the employee. So, my lords, this here is not the notice provision. That's just an award on the finding that the dismissal was unfair. And then 46 sets out how that is to be calculated, how the basic award is to be calculated. And 47 deals with the calculation of compensatory awards.
I'm sorry, you dropped your voice in under
Section 47 deals with the calculation of the compensatory award.
Yes.
But I think I'm looking for an authority that says you can get both.
Basic and compensatory?
No, that you can get both damages in lieu of the notice period plus a basic and compensatory award under the unfair dismissal. I thought that was your proposition.
My lord, under the Employment Act, Section 29 provides for notice pay. The awards that's mentioned, the basic and compensatory award, takes into account the treatment of the dismissal once the matter appears before the tribunal. So an employee is entitled, provided it's not summary dismissal, to notice pay or payment in lieu of notice. That's what Section 21 provides. When we come to Section 46, we're now looking at the treatment of the dismissal by the tribunal. And what it says is that if the tribunal finds that the dismissal was unfair, then it shall go on to calculate these compensatory and basic award.
What do you say about Section 48.2 on page 573? Which, doesn't it require the tribunal to take into account payments made by the respondent as required by law?
Yes, my lady, that's correct. So if certain payments were made before the matter, before the tribunal gives a decision, then the tribunal will consider what has been paid before.
Well, that if there are requirements to pay notice period, they are taken into account when calculating the basic or compensatory award, aren't they? Isn't that what it means?
Well, just a minute so that I'm following you. Well, it said, m'lady, it is hereby declared for the avoidance of doubt that the limit imposed by this section applies to the amount which the tribunal would, apart from this section, otherwise award in respect of the subject matter of the complaint, after taking into account any payment made by the respondent to the complainant in respect of that matter and any reduction in the amount of the award required by any written law. As I understand, my lady, the question is whether or not that would take into account notice pay, or any payment made in lieu of that. It would be deducted, my lady.
It would be deducted?
Yes.
But if that's the case, we then arrive at the proposition or the position that the award given by the Court of Appeal is more generous than would have been awarded under the statutory unfair dismissal legislation, as I understand it.
My Lord, under sections 29, the Court of Appeal increased the notice pay, that's 29(1)(c)(1).
Yep.
But he was also entitled to an additional 48 weeks' pay under C2. He would have also been entitled to a basic award under Section 46. So the 174 that the Court of Appeal reduced the award to would not have been more generous than what he would have been entitled to had they calculated strictly in accordance with the Employment Act. My Lord, perhaps I'm not being very clear. Notice pay under Section 29(1)(c) requires the payment of 1 month's pay in lieu of notice, and at C2, 3 weeks pay for up to 48 weeks. When the appellant was dismissed, he was paid about $97,000 that they say took account of Section 29(c). The Court of Appeal gave, I don't want to misquote them, the Court of Appeal said that the 1 month's notice and payment in lieu of notice was too small. They increased that to 18 months. But he was also entitled to 48 weeks pay, 3 weeks pay for up to 48 weeks, which the respondent gave them. That totaled $90,100. Perhaps I'm not very clear, my Lord. I'll take you to the court to 29(1)(c). Under 29(1)(c), where an employee holds a supervisory or managerial position, 1 month's notice or 1 month's basic pay in lieu of notice. The court increased this to 18 months.
They were limiting, I thought they were just treating it as a whole. They weren't giving him 18 months for Roman 1 and nothing for Roman 2. They treated it as a whole. They gave him 18 months notice to replace the minimum notice that he'd been given under Section 29(1)(c).
The way the Court of Appeal worded it, my lady, and I'll take your lordships to that, the Court of Appeal said payment in lieu of notice, and then they go on to set it out, 18 months pay at $75.08 per month.
I think the point that's being put to you, though, is that the cap in Section 48 applies to everything on the face of it, and therefore he got above that cap.
He got above the cap for notice pay. There's no question about that.
Well, the cap applies not only to notice pay, it applies to any other entitlements he could have got.
My Lord, I'll take the court's point on that. But certainly under Section C2, The Court of Appeal seemed to have increased that award to about 18 months' pay from the 1 month's pay. That's what they said. I'll take your lordships to the decision, which
How
is
does that help you? How does that help you?
I was answering the point, my lord, that
Yeah.
the award was more generous than what he would have been entitled to, or that the Court of
Yes,
Appeal's award
so you accept that it was more generous than what he would have been entitled to under the Act?
With respect to notice pay, that's correct.
No, with respect to any award, 48.2 makes it clear that the cap applies to everything, notice pay and basic and compensatory awards. You just accepted that.
My lady, the basic pay and the payment in lieu of notice are two separate payments under the...
They are, but they're both subject to the cap you accepted in
We accept that
section
it's 20,
48.
yes. We accept that there's a cap at 24. We accept that.
Which applies to everything, notice, basic award and compensatory award.
Yes.
And therefore the Court of Appeal's award, however you describe it, whether you call it an unfair dismissal award or a notice period award, is more generous than what he could have got under section 48 in total.
My lord, I will take the court's point on that, except to, and I will just make one further point, and then I'll leave it alone.
When you say you will take the court's point on that, you're accepting that
Accept
that
the
is
position,
case?
my lord, yes.
Thank you.
And my lord, just to wrap up that point, I will take the court to page 312, which is the final page of the Court of Appeal's judgment, where they addressed the payment or compensation in lieu of notice.
Court of Appeal
Judgment.
Paragraph
95.
95. Yes.
And at page 312, at paragraph 95, I find, therefore, that the intended appellant is entitled to the following compensation in lieu of notice. Monthly salary, and then they calculate it by 18 months, which is $35,520. They seem to be saying there, my lord, that the payment represents compensation in lieu of notice. And that is the award that comes under 29(1)(c)(1).
No, but surely what they're doing here in paragraph 95 is calculating the compensation for wrongful dismissal where insufficient notice had been given according to the terms of the contract in clause 14.2.
That is what they attempt to do, yes, my lord.
Right. So they're not tying that into section 29 as such. They're just looking at what the contract term is. It just so happens that in the background, section 29 provides for a statutory minimum notice requirement and payment. But here, on their interpretation of the specific contract, you're way in excess of what you get under section 29, so you don't need to worry about section 29 at all.
That would be correct. The
Right.
18 months would be way in excess of the section 29 provision, except that, my lord, keep in mind that what the plaintiff pleaded was not unfair dismissal. He pleaded unjust dismissal in breach of his contract of employment.
Yeah, and that's what, on my understanding, that's what the Court of Appeal is calculating the damages for.
Except that, my lord, under the Employment Act, there is no requirement to take into account the criterias for payment in lieu of notice and notice pay that are mentioned in section 14.2.
Right, but if I may put it this way, so what? Since what is the compensation awarded in paragraph 95 is way in excess of anything that you'd get under your Employment Act rights.
Those criteria work to his advantage in this case, is another way of looking at it, because there were things like seniority, loyalty, length of service, which he did well on.
That's why it's pushed it up so high to 18 months, well in excess of his statutory rights.
Yes, Lord, we accept that under 29(1)(c), that is, 18 months will be well in excess of the notice pay that section that the Act gives. We accept that. But then the Court of Appeal goes on to use the multiplier of 18 months to also give other benefits and entitlements, or calculate the other benefits and entitlements under his contract. So that is not a notice provision.
Well, some people would say it is.
Yeah, I'm surely it's compensation, because they shouldn't have dismissed him summarily. He should have been in employment for another 18 months. If he had been in employment for another 18 months, he'd have had
all these
additional
benefits,
Yes.
as well as his salary.
Yes, that's correct, my lords. So, my lord, I cannot take that point any further. My lord, I believe that that is, I've answered. That is the case, my lord, for the appellant.
Thank you very much. Mr. Rogers.
Good afternoon, my lords, my lady. I'm not sure how the court wants me to proceed, given the time. I know we were slotted for 12:30 until...
Well, you're starting early.
Okay.
You don't get extra time.
Well, hopefully I'll
You
be
get the
quick.
same amount of time.
and we'll do the maths.
I'm going to leave that totally in your hands, my lords. My lords, I guess I'm a little bit surprised at the direction this matter is taking this morning based on the case as stated in the written case. As I understood my learned friend's written case, she was not trying to necessarily equate unfair dismissal and unjust dismissal and seek benefits pursuant to the unfair dismissal clause inside the Employment Act, and plus the compensatory benefits for notice under Section 29. What I understood her position to be is that as we read Article 14.2, when we look at the issue of, you have to look at the criteria, plus, and this is her relying on the Andrew Gilbert case, you must give some kind of reason or justification for the termination.
Well, she does make that argument.
Right, and we say that is pretty wrong, but we didn't understand the other aspect because inside her notes or her written case, she doesn't go on to elaborate as to where that takes the court if she was correct in terms of how the award should have been calculated. There's no case law or anything along those lines, and as correctly pointed out by my lords, Andrew Gilbert doesn't really take us any further in terms of the calculations because they only award something in the region of 6 months.
9.
Or 9 months, yes, my lady. So, even with that said, I would like to take a few steps back and start off by looking at the pleadings, because that's how we got here today. And it's interesting for my learned friend, in me looking at her written submissions or written case, because they make the point that explanation, based on the Gilbert case, an explanation should have been given. And we say that they're stopped from raising that point because in the pleadings at the very outset, in the reply, they say that they admit that there is no reason to give a reason or a justification, for the termination pursuant to Article 14.2. And we say that's in all lines with out there because the reality of it is there must be some mechanism in every employment contract where you can terminate without having to pay, justify the termination, so long as you properly compensate the person. And most of the authorities that are before you this morning, they refer to Asadabe, who is considered to be authority in the Bahamas. He wrote a book on the labor laws of the Bahamas, and he speaks to the fact that every employment contract has to have a mechanism whereby you can terminate somebody, either one for no reason. In such circumstances, you have to pay them notice, or for justification or cause. In such circumstances, you don't have to pay them anything. If my learned friend's proposition was correct, based on the Andrew Gilbert case, and we say, again, that she's not entitled to rely at this stage because they're stopped from, because they admitted that an explanation is not necessary. But let's say that was not the case, we would say that it's still, that would be the incorrect interpretation, because if I give you a justification for the termination, then I might as well terminate you for cause and pay you nothing. Now,
Well, is that right? I mean, you might not have a cause that would be sufficient, but it might be a matter of fairness that you explain to somebody why you have decided to terminate them on notice. I'm just wondering. I mean, it must feel quite distressing just to be shown the door without any explanation that they don't think you were good enough, or that they don't need you anymore, or at least something to explain why you're being
well, but there's circumstances where you just may not have a reason at all. I mean, I might bring you in as a good employer and give you a good pep talk and say, you know, it's not you, it's us, one of those speeches. But so long as I properly compensate you in accordance with the common law and or now the Employment Act, which 2001, which sets out the minimum criteria for notice, you know, we shouldn't have to give you a justification or a reason. I tend to find favor with what my lady had to say earlier in terms of how Article 14.2 possibly could be interpreted, and it's a matter of so long as we follow the criteria, as in we put our minds or lend our minds to the fact that the length of time the person's been there, the contributions they've made to the company, any special degrees, and the criteria that's set out. And this criteria is actually akin to the criteria that's been long-standing in the common law of the Bahamas before the Employment Act gave us the statutory minimum. So what would normally happen is I might not have a reason or a cause to terminate you, but based on this formula, and we've provided the locus classicus cases from the Bahamas with Tropigas and Royal Bank of Canada. Those cases speak to the fact that in order to determine what's reasonable notice in all the circumstances, the starting point, of course, is to look at the contract. If the contract is silent on it, because the court would be slow to interfere with the contract. So if the contract's silent on it, then we look at the criteria, that criteria that's set up. And that's actually been specified in Article 14.2, because there's been when the employment, just I guess a little bit of history, when the Employment Act 2001 was brought into being, there was a lot of case law that said that, okay, so long as an employer paid out the statutory minimum, that was the end of the matter. And then came along it's the Paula DeVoe case, where the Court of Appeal said, no, that's not quite right. They can, an employee can make the election to either accept the statutory benefit or pursuant to Section 4, they can elect to have their compensation assessed pursuant to the common law, which is that same criteria. And it's a risk they take, because at the end of the day, based on that same criteria, a judge may find that the statutory maximum or the statutory benefit is actually better than what we are prepared to give you. There's been now, recent years, case law in the Bahamas that says that, listen, even if the contract is silent on notice pay, then properly you still go to the Employment Act, and despite Section 4, you're not to look at the common law. Even if you look at the common law, we're bound by the statute. However, for the purposes of today's hearing and the interpretation of Article 14.2, I guess, which is what this has become pretty much, we say that the common law has been, and the principles have been incorporated into Article 14.2. And the Court of Appeal recognized that. And my learned friend spoke to the fact that the Court of Appeal treated this as an unfair dismissal case. That's not quite right. That's actually very wrong. The Court of Appeal made it very clear.
I think what she meant was that they equated unjust as unfair,
Yes.
and said he never pleaded an unfair dismissal case, and therefore he was left with his contractual remedy. I think that's what she was addressing.
Yes, my lady. If that is what she's stating, then we tend to agree with that proposition to the extent that in the court below, although the judge does not state on what grounds or information or evidence or law she made her findings, she found for breach of contract. And what she did say was that as sparse as the pleadings were, the only thing that was before her was a breach of contract matter. And I guess just to assist the court, though, my learned friend also said that something along the lines of the fact that unfair dismissal was not an issue because we were dealing strictly with wrongful dismissal and this unjust provision. But at EB 158, which is the closing skeleton arguments of the now appellant, it doesn't actually have.
Where, what's 158? So this is in the Court of Appeal, is it?
This is for for the Supreme Court, the closing submissions for the Supreme Court.
Right.
That were filed by on behalf of Mr. Ervin. And at the second paragraph there, they assert that there are 3 tiers of awards to consider. Number 1, there was early retirement damages, and this was something that was never pleaded, never addressed, never argued before the court.
Well, sorry, I thought this is them arguing it before the court, isn't it?
Yes, Lord. And then they say number 2, unfair dismissal. So the court definitely had, but yet no unfair dismissal was particularized in any of the pleadings. That was not borne out in any of the pleadings. That was not argued before the court.
And that's put forward as an alternative.
And that's put forward as an alternative. And then, of course, wrongful dismissal. But I only draw that to your attention as to why, in looking at unjust, because as my learned friend already conceded, the pleadings were very scant, so you didn't really know the case that you had to meet. So in order to cover themselves, respectfully I submit, the Court of Appeal would have had to address the issue of whether unfair dismissal was a live issue in this particular matter. But at the end of the day, they concluded unfair dismissal was not a live issue. They did not rely on the principles of unfair dismissal when they made the award. They made it strictly on contractual basis. So going back to my learned friend's arguments, or written case, I should say, my understanding is that she's saying that the notice provision was breached, and what kind of throws everything into array as well, my lords, is that there's a lot of back and forth between Article 14 and Article 15, and also they make reference to Article 16. But this, as I think has been accepted by everybody, was never a situation where the grievance procedure was invoked. This was never a situation where they alleged that Mr. Ervin did anything wrong, and thus we're terminating him, but we're going to pay him out. The fact of the matter is that we're going to pay you out, so it was without cause. So we say that, and it was accepted, Article 15 and Article 16, which was never pleaded, never became a live issue for any of the court, or was not considered to be a part of Article 14 and the reading of, or
I think it was pleaded.
Exactly.
Yeah. But I think what's being said is that the unjust provision in 14.2 is a contractual right not to be unjustly terminated, and that brings in some separate non-statutory contractual right to be told the reason for your dismissal and to be treated in a just way.
Well,
I think that's what...
And we say the better interpretation of this particular clause, bearing in mind that this is separate and apart, Article 14 is completely separate and apart from Article 15, which requires the grievance procedure and the need to give reasons. And it's understood why you may have to give reasons under those provisions, because you're saying you did something wrong. In this instance, we're saying that you didn't do anything wrong, or we're not relying on any wrongdoing. We're just terminating you, and we're going to pay you out in accordance with this provision. And we raise this inside our written submissions. What we say is, if I am terminated, and I've been there for 50 years, my learned friend here has been terminated, she's been there for 50 years, we held the same position, we contributed the same, then properly we should be compensated the same based on that criteria for the most part, or it should be somewhat similar, because you're applying the same facts and circumstances to the criteria that's listed that must be followed. And if you do not do that, if there's something very exaggerated between the payouts, so in other words, I get paid $1,000 and she gets paid $1 million, then properly that's unjust in all the circumstances.
So you say it only qualifies the question of reasonable notice?
Yes, my lady. And it deals with the issue, and that deals with the issue of what was said earlier about fairness. Is to ensure fairness in terms of the payouts of notice pay.
But if you're going into fairness, why should you limit a more general right of fairness? Why should you limit it to comparison between two individuals? Why shouldn't it be broader than that? And injustice is not limited to when you pay somebody more than somebody else. There may be all sorts of principles that might be considered relevant.
Well, it's my respectful submission that for the purposes of this particular provision, yes, unjust may open the door for a number of interpretations, but for the purposes of this particular provision, which we're concentrating on, where we say that it gives the corporation the right to terminate an employee without cause. Otherwise, again, it would make it nonsense if we have to terminate with some justification of cause, because then therefore we might as well not pay that person, or it will then invoke this whole procedure that we'd have to embark upon. Whereas, and so this would have, if that was the line of thinking or the intention, then Article 14 would really be a subset of Article 15. It would be included in that if that was the correct interpretation, that something more should be read into the term unjust.
Did I understand you to say, when you were dealing with the history, that there was a time when the courts took the position that you had to choose between going for contractual wrongful dismissal damages or going for unfair dismissal compensation, and you would be lumped with one or the other?
Well, my lord,
because I was thinking that if that was so, then this could be seen to be addressing that by saying that that there's whatever happens, you won't. Is essentially incorporating the unfair dismissal into the contractual regime, and saying that that will represent the minimum that you get.
Well, my lord, a mighty long time ago, I had the opportunity of looking at your statute laws as it relates to unfair dismissal, and also our statute as it relates to unfair dismissal, and they're very different, actually. Right? If you allow me, I'll take you to page 570.
570.
Sorry, 567. Sorry, 567. And you see our statute, and as we all, I think, is accepted by all, unfair dismissal is a creature of statute, so we have to be governed by the provisions of this particular act in the Bahamas. And if I'm reading starting at section 34, it says, every employee shall have the right not to be unfairly dismissed as provided in section 35 to 40 by his employer. Thereafter, subject to sections 36 to 40, for the purposes of this part, the question whether the dismissal of the employee was fair or unfair shall be determined in accordance with the substantial merits of the case. The approach when this act first came into existence was a very restrictive approach. It was thought originally that as it's read, or as I read
You were
it,
limited to section 36 to 40, were you?
yes, and that's how it was applied.
But that's now been accepted as wrong, and it's been expanded by,
Yes, my
by
lady.
the judges.
Exactly, my lady.
So any
in
reason-
recent case law, it's been expanded. But I only say that to say, but the expansion has gone into situations where, such as breach of natural justice, where I terminate you for cause. I assert that you did something wrong. I do not pay you your notice pay or any pay that you may be entitled to in a wrongful dismissal action. And you turn around and say, well, you terminated me, it was unjust or unfair. Based on the merits of the case, I'm able to demonstrate when you're summarily dismissed, there's certain criteria under our Employment Act and under the common law, of course. The Employment Act speaks to a reasonable investigation. And so what has usually typically been held is that in order to conduct a reasonable investigation to a matter, I have to approach the employee, question them and put the wrongdoing to them in order to at least ascertain their position as to what they may have done wrong in the circumstances.
So it's got a procedural aspect to it, and
Exactly.
it's got
And if you
a
fail on-
substantive aspect to it. You have
Exactly.
to have a reason, and you have to act fairly in treating that reason as a good reason to
To
dismiss.
terminate them. And if it's decided that you did not, then they're unfairly dismissed. But it is not in a situation such as this, where a person is not terminated for cause, but they are terminated pursuant to a notice provision.
Well, the employee could still come along and run an unfair dismissal case, even if terminated without cause, and say, it was grossly unfair. I was humiliated in being escorted by security guards out of the premises. I had an unblemished career.
And that's
He
a
could
possibility.
still
my
run
lady.
an unfair dismissal case.
And that's a possibility, my lady.
I'm not saying he did, but
Yeah,
he could have.
that was the point that I was going to make. That's a possibility, my lady. And I think that there's persons who are now, I don't think that has been fully developed in our jurisprudence, but I think there are cases in the pipeline that are approaching that particular way. But the point is, for the purposes of this particular action, none of that was borne out in the Supreme Court or before the Court of Appeal. And so that was never a live issue, and we say properly it should not be a live issue here, in the sense that this was never the case made on behalf of Mr. Ervin Dean.
So still, I mean, it does say in the clause that you'll get compensation no less favourable than under the Employment Act. And if it's easy to calculate the basic award under the Employment Act, and if the result of the contractual computation had been less than that, it would have been pretty hard to send him away without that, when the contract clause expressly says that that's the minimum.
Yes, well, but we say...
I know that wasn't the case here, because he got more than that, but I'm just looking at what the meaning of the clause is.
Yes, well, but in reference to in reference to the Employment Act, we respectfully submit that because this is a clause germane to notice, we say that properly the provision that this relates to when it refers to the Employment Act, although it's not specified, we say that properly this relates to Section 29 and the relevant notice pay that should be paid to an employee when terminated without cause.
So it's making clear that you get what's reasonable under the contract, and if that's and that can't be less than what the minimum specified in Section 29 is, but it can be more.
Yes, Melanie, that's exactly the point.
So just to be clear as to your previous submission, you were saying that the courts in the Bahamas have been expanding the ambit, if you like, of the unfair dismissal legislation so that it includes further substantive grounds, procedural grounds, and that's your analysis of what's been happening?
Yes, my Lord. Yes, my Lord. I'm not saying that I've ever agreed with it, and I'm not saying that they got it wrong either. but that's what's happened. Initially, it was a very restrictive approach. It was my understanding of the creators of the legislation that it was intended to be restrictive, but the arguments have found favor whereby the court have now, as I indicated, not that there's not other grounds for claiming unfair dismissal now that the door's been open, but it's mainly been attached to cases whereby somebody's been terminated for cause and they claim wrongful and unfair dismissal. As it relates, if I may, as it relates to also again what my learned friend had communicated to the court, she had indicated that the Court of Appeal had calculated or made their calculations based on unfair dismissal, and if that is the case, then it should open the door. We only wanted to bring, I just wanted to bring to your attention well, two things. It would be E. Yeah, 37. It would be 301. Paragraph 37, and it's the last sentence in that paragraph. And this deals with the issue of what the Court of Appeal addressed its mind to. And they actually state emphatically, I would say that although not specifically pleaded, the issue of wrongful dismissal was front and center in this case. And of course, the case has stated in the agreed statement of facts has always been one of quantum as it relates to Article 14.2. And so if it is determined that there was a breach of contract, well, what is the compensation for breach of contract in a dismissal action? And it would be akin to wrongful dismissal, and that's what they address their mind to. So even though the court, the trial judge mentioned breach of contract, well, it was a breach of a notice provision. That was the actual alleged breach. The trial judge didn't specifically state what the breach was or what provision was breached, but the Court of Appeal made a determination that it was a breach of the notice provision in that the BPL, the now respondent, did not adequately compensate the appellant based on the Article 14.2 notice provision. And so then we turn to, within the ruling, page 309, paragraph 87. Well, actually, I'll start above that, Lois. If we look at, we respectfully submit, the Court of Appeal then embarked, starting at paragraph 82, this is page 309, they did exactly what the trial judge failed to do. So in other words, they addressed their mind to section 29, and that's where they determined that there was a breach. It states the intended appellant was in breach of the contract between themselves and the respondent because we paid the person in accordance with, the appellant in accordance with section 29 of the Employment Act, as opposed to following the criteria of Article 14.2. Unfortunately, when we appeared before the trial judge, we were not able to establish that through the witness that we had, we were not able to establish that BPL, although they may have didn't consider the length of time and the criteria. We paid the Section 29, and then we paid an additional amount on top of that, which we argued was sufficient pay, given the circumstances, but that did not find favor with the court below, and that did not find favor with the Court of Appeal. So they addressed their mind to that issue, and they demonstrate exactly what the breach is. And I reiterate the special point, that is a breach of the notice provision, not any other provisions. And then the court went on to say, I am satisfied that this appeal, this is 83, that this appeal does not have a good prospect of success and regarding the judge's finding of the breach of contract. So they accepted there was a breach of contract, but the problem was we didn't know, based on the judgment of the trial judge, what the breach, what she determined to be the breach. She repeated the submissions of the now appellant, then plaintiff, and she repeated the submissions of the respondent, defendant, and then just simply made the bare assertion that there was a breach of contract. But we didn't know what provision or anything along those lines. So the Court of Appeal was doing a bit of housekeeping. And I mention all of this to demonstrate that there was a real need for the Court of Appeal to interfere with the rulings of the trial judge, because in the exercise of her discretion, we didn't know what law she predicated her discretion on, or what
are you saying that's in relation to quantum or in relation to liability?
In relation to both.
As I read 22 and 23 of her liability judgment, she's saying that the terms in effect of Article 14.2 mean, and Section 4 of the Employment Act, mean that if you've got better rights to notice under your contract than the minimum rights under Section 29, then the better rights apply. And then at 23, she refers to some of the features of the appellant's service and circumstances that meet the criteria in Article 14.2, like his age, his length of service, that he dedicated his life to this defendant corporation. And then she concludes that there was a breach. I know she also refers to 15.7, but leaving that to one side. So can't it reasonably be inferred that that is her finding?
Yes, my lady.
And the Court of Appeal supported that?
Yes, my lady.
So why are we worrying about the liability aspect?
No, I was only saying, my lady, in terms of the facts that she relied on. I'm not challenging, because I'm just saying the Court of Appeal solidified the position as to what they were relying on when they made the determination to reduce the
Right. Okay. Sorry, I misunderstood.
That was the only real point. I wasn't necessarily challenging the finding of breach of contract. I was just saying that it was very difficult to ascertain, what facts she accepted as proven facts, and so forth. Especially when it comes to the fact that she made such a astronomical
Well, that's a different
award.
point.
Because it begged the question, well, on what basis did she feel that the appellant should have been compensated right up until the age of retirement? And you'll see that has been their case throughout. It's not looking for reasonable compensation. It is a situation where they're saying he was 54, he retired in another 7 years or so, and we want full compensation up until that period. And there's no case law before the court or facts that prove that he would be entitled to that. So the second point was that at 83, I'm satisfied that this appeal does not have a good prospect of success in regard to the judge's findings for breach of contract, which we accept, but it does with respect to the payment of 74 months. And then 84 goes on to, the judge's order for payment of 74 months must be set aside as there is no evidence to support such a handsome windfall. And they go on to say, I might add that not even counsel for the intended respondent could provide a precedent or authority that supports such an extraordinary period of time. And we submit that that still remains the case. In my view, the amount of the judgment award is so excessive that an appellate tribunal would be justified in interfering with her assessment. And then at 86, the point to be made here is that the court addressed its mind to whether or not they should remit the case or whether they should make the assessment. And we respectfully submit that the evidence before the court below was very limited. It was not complicated, and this is not a case where we had to, the judge had to be minded of the credibility of the witness in the box. And so the court felt as though they were in a place to consider, just as much as the trial judge, the evidence, well, proven evidence, I should say, and make an assessment. And despite my learned friend's argument that it was an arbitrary assessment and that, or alternatively, that it was an assessment on the basis of unfair dismissal, at 87, we see that they make it very clear that they're looking at the principles of wrongful dismissal, and I quote, the principle as distilled in the cases stated that an employee who has been wrongfully dismissed is entitled to damages as well, as will compensate for the wrongs suffered. The basis is that a claimant employment is terminable on reasonable notice. Where an employee is wrongfully dismissed without reasonable notice, the award of damages to which the claimant is entitled is to compensate for the loss that flowed from not having been given such notice. And so if we turn over to the following page, it says, even more importantly, it is clear from the authorities that the claimant cannot be compensated for the period until the age of retirement as claimed. The claimant can only be compensated for lack of reasonable notice. So the fact of the matter, boys, is that the learning, there's many cases, some are contained inside bundles as well, but there's so many cases that we could have relied on that state a very similar principle. We refer to the case of King, and I won't take you to it unless you want me to, of course. But it basically it's a another Bahamian case. It's a Bahamian case, sorry, that reiterates and makes the exact same point that there must be some mechanism so that a contract is not indefinite. You should be able to terminate an employee either for cause or through the payment of sufficient notice. And so at 93, you find them saying, nevertheless, given all of the factors mentioned as peculiar to the intended respondent, so they're demonstrating that they considered the factors of how long he's been with the company, the proven facts, so to speak, as they relate to the criteria. Because it was always our argument before the courts below that the plaintiff, he who asserts must prove, the plaintiff failed, or appellant failed to prove to the court sufficiently, any special training, or he only proved maybe 2 or 3 out of the 5 or 6 criteria. That was only proven during the course of the trial. So the court here is saying, bearing that in mind, they've considered the evidence, and as a result, that's how they came up with the calculations of 18 months. They felt as though, given what was proven in the trial, and based on the case law and what may be considered reasonable notice, they deemed 18 months reasonable notice. And it's my respectful submission that that is not outside the range, and respectfully, this honorable court should be slow to interfere in circumstances where they've addressed their minds to the breach, they addressed their minds to the lack of authority to support a windfall of 74 months, they addressed their mind to the evidence, and whether they erred, and I'm not saying that they did, whether they erred in attaching significance to not enough significance to just or unfair and so forth. It does not interfere with the calculations or the formula as to what the appellant would be entitled to when considering a breach of contract or in the circumstance of wrongful dismissal. We're just dealing with the notice period. The notice period being what is spelled out inside the Employment Act, and they have the formula. The formula is followed by the Court of Appeal because they award above and beyond the statutory minimum, which in these circumstances we submit is Section 29 statutory requirement, as that's the statute akin and deals with with notice pay. And just as a side note, without delving too much into it, because there's no cross appeal before the court, we even go so far as to say they were overly generous because there is just a little bit more of a, employment labor law for the Bahamas that's, unique or peculiar to the Bahamas. There's actually an ongoing consideration regarding the benefits when notice pay is paid out. In this instance, health insurance was awarded, car allowance was awarded, telephone allowance was awarded, rostering allowance was awarded, and during the course of the trial, we argued that this was not proven because there was no documentary evidence to prove it. But also, there's a case, Life of Key Members Club in the Bill Shawan, in that the Court of Appeals spoke about convertible and non-convertible benefits, and they akin these to what would be considered convertible benefits. Non-convertible benefits, and properly an employee would not be entitled to these upon his termination, as in not even during the notice period. Now, I only just raise that as a side point. It's not something that I'm embarking upon unless the court wish me to take you there. Or
You're not going behind the Court of Appeal. There's no cross appeal. Yeah.
No, that's what no, my lord.
Sorry, can I just ask one question? Is there a qualifying period before you're entitled to claim unfair dismissal in the Bahamas, like there is in this country, or can you, from day one of as a probationer, say, claim unfair dismissal?
That's the interesting point, because under the Section 29 provision, there's a qualifying period. It says, essentially, unless you have been employed for 6 months, a manager, the argument has been run, under Section 29, a manager and employer is entitled to that 1 month and 1 month for every year from day one.
Right.
There's no qualifying period. With regards to line staff, or what we refer to as line staff, as in non-managers, non-supervisors,
Yep.
After 6 months of employment, then you qualify, between 6 months and 1 year, you qualify for 1 week's notice.
So you can't claim it before 6 months?
No, you can't.
But sorry, if I may say so, you seem to be talking about the minimum
Yes.
notice periods under Section 29.
Yes.
The question was directed to the unfair dismissal right under Section 34.
Yes, well, no, I was just giving her a little background. I was saying it's kind of peculiar because it's specified in the Section 29, but I never looked at it, but it's not specified. There's no qualifying period. As
Section
I saw it.
34 just says employees.
Yes, my lord.
Yeah, it says every employee.
Yes.
It's going to cover everyone without a qualifying period.
That's my lord.
And do I understand right that you can choose whether to bring your claim in the industrial tribunal or in the court?
Yes, my lord.
The claimant is free to choose either.
Yes, that's actually been dealt with as well during the development of this particular act, because initially, again, when it came out, there was a lot of debate and argument before the courts that properly, now that this act was in place, a lot of the matters, including, especially since in the unfair dismissal provisions, it speaks to you have to go before the tribunal. But it's been held that you have the election, you can go before the tribunal, or the Supreme Court is what.
For unfair dismissal under the legislation.
For any aspect of the Employment Act, any labor issues, you can go before the industrial tribunal or the Supreme Court. And as I indicated, I think that address is most of what was raised by my learned friend. As I indicated, most of everything that we have is contained in our written case. I don't know if the court has any other questions. It'd be my pleasure to answer it since this is my first time, so I'm I have to make the most of it.
We're very grateful to you. Thank you very much.
Much obliged.
Ms. Byfrom.
My lords, I wish to address your lordship very briefly on the pleading point. My friend has submitted that the appellant or the plaintiff below hadn't pleaded any matters relevant to the claim for breach of contract and the claim for unjust dismissal, so that they were caught by surprise in defending the claim before the lower court. Now, my lord, the amended statement of claim can be found at page 23. And I'll take your lordships to it very briefly.
Bear with us a moment, if you would. Page 23.
22 and 23. And there your lordship will see that at paragraph 3, the plaintiff sets out that his conditions of employment are contained in the industrial agreement. And then he sets out the particulars of the agreement. Pursuant to Article 14, the corporation may terminate the services of an employee by giving reasonable notice. And then he goes over on the following page to say, however, the corporation shall not terminate an employee unjustly. At paragraph 4, in breach of the contract of employment between the plaintiff and the defendant, on the 22nd of September 2017, the corporation made a decision to terminate his employment without notice, effective immediately. Under the heading Particulars of Breach, at 1, he sets out the corporation failed to have regard for the length of service, age of the employee, etc., and the corporation terminated the plaintiff unjustly. So, my lords, the argument advanced by the respondent that it was unclear at the trial what the claim was is not on all fours. Certainly, and I'll go on, my lord, before I make my submissions on that point. At paragraph 5, the plaintiff's letter of termination did not state any grounds or reasons for the termination, and to date, the plaintiff still has not received any explanation as to why he was terminated. At 6, the plaintiff received no warnings or any other form of discipline prior to his termination, as is further required under the industrial agreement.
Well, that would have been Article 15.
That's the Article 15 claim, yes.
And that was you. The judge said you weren't entitled to.
Yes,
Yeah.
the Court of Appeal found we were.
The Court of Appeal, sorry.
Yes.
And you haven't challenged that.
Sorry, my lord?
You're not challenging that.
The Court of Appeal found that there was nothing pleaded in that regard.
But you weren't entitled to an Article 15
Because it was without
disciplinary
cause.
process.
Yes, because
right.
it was without
You
cause.
accept that?
Yes.
So what would reasons have added to your breach of contract claim?
Sorry, my lord?
What did the absence of reasons add to your breach of contract claim? How did it make a difference?
My lady, when one looks at the industrial agreement itself, there are only 2 places in that industrial agreement where unjust and an injustice has been committed is mentioned. And under Article 15:14, that is the provision that says if an injustice has been committed under the terms of this agreement.
No, I understand, but you've just accepted Article 15 didn't apply.
Normally,
I'm asking you what the absence of reasons in a case where you accept Article 15 doesn't apply would have added to your breach of contract claim.
We say, my lady, that had a reason, or sorry, in the absence of reason, the claim itself would have failed to be considered under Article 14,
Yes.
which means that we ought to have been given, that the dismissal itself would have been unjust, and that in line with the decision of Andrew Gilbert and BEC, reasons had to be given.
But what compensation, as a matter of contract, were you entitled to for the absence of reasons, given that you were not being dismissed under Article 15?
Well, Lady, that is just it. The industrial agreement, unfortunately, doesn't say.
Well, what are you claiming? What are you saying the Court of Appeal should have given you?
We are claiming that we ought to have been given, under the terms of our contract, his lost salary for the period when this matter, from the period of his dismissal to when the learned judge directed that his dismissal itself was unjust.
For the... Sorry,
From the
say
point
that
at
again?
which he was dismissed,
Yeah.
up to when the learned judge determined that the dismissal itself was unjust. And that would have given him a greater award, because he would have been entitled to claim lost salary from the point of his dismissal up to when the tribunal, here the court, determined that the dismissal itself was unjust.
Do you mean the date of the court's decision?
Yes, my lord, it's the date of
But that's just an arbitrary, that depends on how long it takes to come to court. You know, if it comes very quickly, you get very little. If you can drag it out for a long time, you get a large sum. That can't be the measure of compensation.
My lords, in Jamaica Flour Mills, that very same issue...
But there was Article 15 in that case. That was a case about... That was a case about unfair dismissal, I'm sorry.
Yes, my lady, what we have here is, in effect, the treatment of employees dismissed for cause having a right to a fair process, and those dismissed without cause not having a right at all. There must be some justification.
Well, they've got unfair dismissal rights, haven't they?
That's the point my lady raised. And so when the court determined, the Court of Appeal treated the claim as one for unfair dismissal, then the employee had a right to perhaps pursue or argue unfair dismissal and the compensation that falls under the Employment Act. But unfortunately, my lady, that was not particularized or pleaded in the court below. And we have to, yes, or argued at the Court of Appeal, my lord, we have to accept that. It was not pleaded and was not particularized. Instead, what the plaintiff did was fall back on his position under his contract, which said that these provisions concerning disciplinary process prior to a decision to dismissal were terms of his contract which the parties had agreed to follow before any decision is made to terminate.
Right, but he wasn't being dismissed for cause, though. It wasn't being said that he's committed any breach of discipline.
Yes, my lord, but the industrial agreement and the provisions in it whereby the parties have agreed that before a decision to dismiss is taken, certain things would happen. The plaintiff's position was that he was entitled, before that decision to dismiss was taken, to a disciplinary process, or to the benefit of the provisions in his contract relating to discipline or grievance, and that was not taken. Otherwise, my lords, what we have is an industrial agreement that contains terms with respect to grievance, and one that gives the employee a right to be heard before a decision to dismiss is taken, but the provision itself is redundant, because an employee dismissed without cause would not have a right to those provisions. It will only apply to employees dismissed with cause. Yeah. And the industrial agreement itself was intended to protect employees as a whole, not just ones who are dismissed for cause. Is my respectful submissions.
By from, can you give us some idea of how much longer you think you'll be in your reply?
My lord, no more than 10 minutes. I just wanted to take your lordships to...
If you're going to be substantial,
We should leave it till quarter past. Carry on till quarter past.
I think better to finish now.
I think so.
Yeah,
Okay, if you're happy.
Yeah.
Yes, very well. Very
Yes, my lords.
well. We'll sit until quarter past, if
So,
necessary.
my lords, my argument was, and I understand Lady Simler's point, if you are dismissed without cause, then what rights do you have under your agreement? But the parties started off on the basis that they would negotiate in good faith and that these provisions, as provided in the industrial agreement, will bind the relationship moving forward. One of those provisions was a right to be heard before a decision is taken to dismiss. But, lady, that's just it. It didn't say for cause. It just simply say before, and I'll take your ladyship to it, the court to it.
Well, I think we've been round this particular roundabout a few times now.
Yes, my lords, and so I cannot take it any further, but I accept, my lady, that, my lords, that there is nothing in the agreement, in the industrial agreement, that protects an employee who's dismissed without cause. Lord, I will only summarize the arguments of the appellant in relation to the judgment of the court. It was argued that the judgment is inadequate for lack of reasoning. And as the court would have noted, the judge set out in her judgment on liability that she had considered the pleadings, she had considered the evidence. She said that she had in her possession the witness statements of both the plaintiff and the respondent, and she then went on to set out what the agreed facts were, and then she arrived at her conclusion in paragraph 26 that there was no justification for the termination, and consequently the respondent had breached the appellant's contract. So one cannot say, against that background, that the judge's reasoning were inadequate. We do accept that they could have been better, my lords. There's no question about that. And we also accept that the pleadings could have been a bit more elaborate. But, my lords, no point was taken in the court below to seek clarification with respect to any of the matters that were pleaded. The defendant merely defended on the basis that the breach of contract that was alleged in the plaintiff's claim, they required the plaintiff to prove it. But, of course, the industrial agreement does not set out any rights of the plaintiff in terms of protection against unjust dismissal. So what could the plaintiff have possibly said with respect to his right not to be unjustly dismissed? There was nothing in it that would give him pleadings or particulars to support a claim for unjust dismissal, except to say that I had a right not to be unjustly dismissed, and the defendant, in failing to allow me, at minimum, an opportunity to be heard, was in breach of my contract. And as your lordship will no doubt be aware, breach of contract attracts its own damages under the orthodox damages principle. And that is the basis upon which the plaintiff pursued its case in the court below. The business of unfair dismissal and the Employment Act was first raised before the Court of Appeal. That was not at all argued before the court below, except that it appeared that the plaintiff would have conflated all of these remedies, breach of contract, wrongful dismissal, and unfair dismissal. But in terms of pleadings, when your lordship looks at the decision of the court below, your lordship will note that nothing was particularized with respect to unfair dismissal. The particulars related to breach of his contract and the rights given to him under the contract. And both parties agreed that the IA, the industrial agreement, binds them, and they agreed to be bound by the provisions in the article. Surely we cannot select what provisions the provisions that will bind the parties. And in my submissions, my lord, if an employee dismissed for cause has a right to be heard, then on what basis would one dismissed for no cause not have the same right? And my lord, I will only refer your lords to the transcript of the hearing before the court below, where the judge would have asked the human resource manager of BPL what it meant or what his understanding of the unjust dismissal.
Well, we don't need that because that's not admissible, is it?
Exactly. Thank you, my lord.
It's not going to help.
But certainly, my lord, it's only to add to the point that everyone was aware of what the claim was in the court below. No one was taken by surprise. The cross-examination was directed to this business of unjust dismissal and what this Article 14.2 means, and that was the basis upon which the court concluded that there was a breach of the contract of the appellant, sounding in damages under orthodox breach of contract principles. Whether she was right, my lord, or not is why we're here. In conclusion, my lords, we say that even if one accepts that the trial judge's assessment was on the high side, it did not necessarily warrant the Court of Appeal interfering with that assessment on the basis that, and substituting its own figures. The Court of Appeal accepted that there was a breach of contract. We must not stray too far from that. They accepted that there was a breach of the employer's contract of employment. So they upheld her finding of liability for breach of contract. So it cannot be said that the judge made a fundamental error of law. And my lord, we all accept that interference by the higher court in a finding of fact by a lower court will only be permitted in very narrow circumstances. At the very least, my lord, we say that the drastic reduction of the award was not justified in the circumstances of the case. He had been a stellar employee for 30 years. And keep in mind, my lord, that they escorted him off the premises with security guards. This is an employee who was...
I don't think that's before the court or evidence, and can't give evidence from the bench, and I'm sorry for interrupting. I'm not sure how the process works, but I just didn't want him to go down that. I apologize.
My lords.
I don't think we're going to be assisting.
Sorry, my lord. My lord, the witness statement of Maurice Williams was before the judge. And it's also before this court.
Well, we're not going to start reappraising the circumstances, what happened now. So, that's a point to make in before the judge, not on the second appeal.
And indeed, this is your reply.
Yes, I accept the point, my lord. So, my lord and my lady, I think that I've covered everything. But may I have a moment to just confer with my judge?
Yes, of course.
Thank you, my lord. That is the case for the appellant.
Thank you very much. Well, we're grateful. Bye from Mr. Rogers, we're grateful to you and to your juniors, and also to those sitting behind you for their part in the preparation and presentation of this case. We're very grateful for your assistance. The board will take time to consider the advice that we will humbly tender to His Majesty, and the court is now adjourned. Thank you very much.
Thank you, Lodge.